Good morning, everyone. My name is Christy McKenzie. I'm the Assistant Coordinator of Neighborhood Services. I work for the County of Erie for the Department of Senior Services. Welcome to the 2020 Virtual Elder Law Day Summer Series. This series will run every Wednesday through the end of September. Please visit erie.gov/ELD to register for an upcoming session. A few things to mention: this presentation is being recorded. You can find this on our website at a later date, along with the PowerPoint that is being used for today. Also, feel free to use our Q&A panel on the right-hand side. Please refrain from putting any personal information into those questions, and we'll address those towards the end of the presentation. I would also like to take a minute to thank those individuals who have helped to make this summer series possible. Our County Executive, Mark Polenkars, Karen Nicholson, the CEO for the Center for Elder Law and Justice, and of course, our Senior Service Commissioner, Davis Shank. Please allow me to introduce our guest speaker. Tatiana Robinson is an attorney at the Center for Elder Law and Justice. Her practice focuses on civil litigation, landlord tenant law, and City of Buffalo housing code violations. Since joining the Center for Elder Law and Justice, she has counseled hundreds of clients on landlord tenant and housing code matters, as well as successfully represented most of those clients in housing courts throughout Erie, Niagara, and Chautauqua County. Welcome, Tatiana.
Thank you, Christine. Hi, everyone. I know that the video is a little bit fuzzy. We're dealing with a webcam, and I also apologize for the noise. I live in a busy area. Okay, Christine, is this okay?
Yes, we can hear you. You can see the slide.
Okay, great. So good morning, everyone. My name is Tatiana Robinson. I am the housing law attorney at the Center for Elder Law and Justice. And today I will discuss with you New York State landlord tenant law in 2020. So as you all know, the COVID-19 pandemic continues, and it has had a dramatic impact on our American court system entirely. But courts at every level have been postponed or canceled proceedings in response to the spread of coronavirus. Even the U.S. Supreme Court building is closed until further notice, but will remain open for official business purposes with case filing deadlines remaining in place. So as a result, landlord-tenant law process and procedure is at a near standstill. But before we get into how the court, the law have been adapted, I would like to start at the very beginning by giving you all an understanding of what landlord-tenant law governs. So, landlord-tenant law governs the rental of commercial and residential property and is primarily composed of state statutes and common law. But today we're strictly focusing our discussion on residential landlord-tenant relationships. Now, residential housing may be privately owned, meaning the federal government, state government, local government, they're not involved with the purchase or renting of the property. It may also be privately owned but publicly funded in some way, meaning the housing is entirely or partially subsidized by the U.S. Department of Housing and Urban Development and/or the federal government has provided the owner tax incentives, special financing, loans, et cetera. It's sort of an incentive for that investor to make that investment to supply subsidized housing to our communities. It's a public health concern. So residential housing may also be publicly owned. When residential housing is deemed public, that means the housing is owned by the government, either local, state, or federal. I wanted to discuss 5 main programs that touch on public/public-private ownership. So we have the Low-Income Housing Tax Credit Program. In the Low-Income Housing Tax Credit Program, developers and investors get tax credits for buying, rehabbing, or building rental housing intended for low-income renters. In exchange, all or a portion of the apartments are set aside for low or fixed income tenants. Your eligible income and your rent will be based on the average income for the area where you live, and many low-income housing tax credit properties are operated by 55 and up or 62 plus communities. Next, we have Section 202 supportive housing for the elderly. HUD provides capital advances to finance the construction, rehabilitation, or acquisition with or without rehabilitation of structures. Rehabilitation of structures. Where is this? that will serve as supportive housing. This housing serves low-income seniors who need help with daily activities like cooking, cleaning, and transportation. HUD provides capital advances to private nonprofit sponsors to finance properties to be used as senior citizen homes. Next, there's public housing. These properties are generally owned by the municipality, state, or federal government. They're affordable rentals for families who are low-income seniors or disabled. And tenants should pay no more than 30% of their income for rent and utilities. Next, there's the Housing Choice Voucher Program, also known as Section 8. This voucher program attaches to the person instead of the property. It allows the person to travel and live really wherever they would like to. So basically, seniors, physically or mentally disabled persons are able to pay rent at privately owned market rate apartments. And again, Section 8 tenants should pay no more than 30% of their monthly adjusted gross income for rent and utilities. The voucher makes up the difference here. And then finally, in subsidized housing, this is generally privately owned but publicly funded in some way, as I mentioned before. And not all the apartments are subsidized, some are market rate. And it's the same thing in concept as the voucher in the sense that they are subsidizing the 60%, the 70% of the rent that isn't covered by the tenant's portion. Okay, I just wanted to ask if anyone has any questions at this point.
I don't see any typed in just as of yet.
Okay. So now we're going to get into the basis of the legal relationship between a landlord and tenant. It's grounded in contract and property law. The tenant has a property interest in the land for a given period of time before the property interest transfers back to the landlord. Now, the two most common forms of residential landlord-tenant relationships are distinguished essentially by either having a lease or not having a lease. In the lease situation, in landlord-tenant relationships covered by a lease, the relationship lasts for a fixed period of time, which is agreed upon in advance by both the landlord and the tenant. The tenant has the right to possess the property and to restrict others, including the landlord, from entering the property. When the period ends, so do the tenant's possessory rights. The second type of landlord-tenant relationship is not covered by a lease and is commonly referred to as a month-to-month tenancy. The relationship is automatically renewed each month, really, unless either the landlord or tenant provides advance notice. So I wanted to mention that since the passing of the Housing Stability and Tenant Protection Act in June of 2019, Real Property Law Section 226C, entitled Notice of Rent Increases or Non-Renewal of Residential Tenancy, lengthened the notice period required to terminate a month-to-month tenancy. So the new law bases the length of notice period on the resident's length of occupancy as follows. So if the tenant has occupied the unit for less than 1 year, the landlord shall provide at least 30 days notice. And this is to terminate or not renew a tenancy. If the tenant has occupied the unit for more than 1 year, but less than 2 years, the landlord shall provide at least 60 days notice. If the tenant has occupied the unit for more than 2 years, the landlord shall provide at least 90 days notice. Now we'll cover some of the basic rules and obligations required of the landlord-tenant relationship. So let's get into lease, rents, and fees. Lease provisions. Leases must use words with common and everyday meanings and must be clear and coherent. That's just the structure of the lease. So if you notice that your lease has terms and conditions that you can't understand or comprehend, you should never sign an agreement that you don't understand. Always ask your landlord or whomever exactly what the meaning is and whether they can clarify it, because if it's confusing, you're agreeing to something that might be vague and it could be used against you in the future. So you want to be clear. You always want to read your lease, go through all the provisions. And if there is a portion that you don't agree with, speak up. Let your landlord know. You can make a note on the side and say, I don't agree with this. And then if your landlord doesn't agree with that, then they'll reject that offer essentially. So rent, a landlord may not raise the rent of a tenant who is on a fixed term lease. So if you've agreed to a lease, your landlord can't arbitrarily in the middle of the term of that lease change any provision really without your consent. If you consent to it, then they can change whatever, but without your consent, they can't just send you a notice, hey, your rent has gone up if you're in a lease. If a tenant does not consent, so with a month-to-month tenancy, it's a bit different because it's essentially renewing each month under the conditions that neither you nor the landlord have terminated. And I'm not sure if any of you watching today are landlords. This is sort of geared towards tenants, but it obviously is pertinent to landlords as well. So a landlord may raise the rent of a month-to-month tenant with the consent of the tenant. If the tenant does not consent, however, the landlord can terminate the tenancy by giving appropriate notice. And that notice will be like the notice I stated before, in terms of, it depends upon occupancy. So if you've been there 1 year or less, it's 30 days. If you've been there between 1 and 2 years, it's 60 days. If you've been there 2 years or more, it's 90 days notice. Additionally, if the landlord increases the rent and it's more than 5% of the total current amount, and you can figure that out by taking your current amount, multiplying that by 0.05, that'll give you 5%. And if that amount is less than what the landlord is increasing your rent, that means that it is above 5%. So if the increase is above 5%, they must provide the same amount of notice necessary to terminate the tenancy, what I just stated before, and also before that. Okay, let's get into entry, because a lot of my clients are concerned about this. So entry is allowed with notice for maintenance and repairs when it's non-emergency. The reasonable notice period, that's been sort of the language used in common law. There's no statute that defines when the notice period, or if there is a notice period, is, or really how the behavior is, except for that it must be reasonable. And this has been interpreted differently throughout the state. There's no statute. Generally, about 24 hours notice has been found to be reasonable. In an emergency, however, your landlord can enter your premises, apartment pretty much unannounced. That's the only situation. If there was a fire or a flood or something, they really should knock on your door and ask, hey, listen, can I gain access to the apartment? But if you're not responding, then they're authorized really to come in at that point. That being said, your landlord is never allowed to enter your apartment unannounced in a non-emergency setting. They do have to knock and see if you're home. So if they say, we're doing inspections on this date, and you don't answer, they can't just open the door and come in. That's not allowed. However, if you don't allow them entry, there might be, consequences for that, depending on what type of lease you're in and whether you have a recertification deadline, something like that. So there are consequences for not allowing your landlord entry, because although you have possession, they're still the owner. So they have an interest in the property, and that allows them access into the property. Let's get into habitability and repairs. This is a really common issue as well. So there's an implied warranty of habitability in every lease, and there is a statute that authorizes this. Whether your lease contains this covenant or not, it's still implied. So your landlord is held to these certain obligations through the state, and if they don't meet them, then you have various defenses or affirmative defenses or things that you can do in order to compel your landlord to make these repairs. Habitability and repairs. Warranty of habitability. Tenants have the right to a livable, safe, and sanitary apartment. This is a right that is implied in every written or oral residential lease. Any lease provision that waives this right is contrary to public policy and is therefore void. Landlord's duty to repair. Landlords of multiple dwellings must make the apartments in the building's public areas in good repair and clean and free from vermin, garbage, or other offensive material. Landlords are required to maintain electrical, plumbing, sanitary, heating, and ventilating systems, and appliances landlords install, such as refrigerators and stoves, in good and safe working order. So if you move into your apartment and it has these things, then even if it's not explicitly stated in the lease, your landlord is obligated to maintain these things in good and working order. If you come in and there is no stove, no refrigerator, and you have to use your own, and yours breaks down, your landlord has no obligation to fix your own appliances. It's just the ones that have been supplied. Um, that being said, if, for example, there's a bug infestation and it hasn't been caused due to your own negligence, you are not the origin of the bed bug source, then your landlord is obligated to take reasonable measures to fumigate the apartment, and they'll have to pay for that. Bed bugs are a difficult topic. I'm sure everybody understands that, mainly because it's like a whodunit kind of thing. Nobody can really prove unless nobody else in the building has bed bugs. But in terms of like structural issues, like your door isn't working, a leaky faucet, etc., you want to make sure that you make a maintenance request first. You can't just up in arms say they're not fixing anything if you don't notify them of the problem. So make sure you notify them of the problem. Entrance, door locks, and intercoms. So multiple dwellings which were built or converted to such use after January 1st, 1968 must have automatic self-closing and self-locking doors at all entrances. These doors must be kept locked at all times, except when an attendant is on duty. So if there's an issue with your front door entrance lock, that's a serious concern. It's a security issue, and you should notify your landlord immediately. Heating. Heat must be supplied from October 1st through May 31st to tenants in multiple dwellings. If the outdoor temperature falls below 55 degrees Fahrenheit between the hours of 6 a.m. and 10 p.m., each apartment must be heated to a temperature of at least 68 degrees Fahrenheit. If the outdoor temperature falls below 40 degrees Fahrenheit between the hours of 10 p.m. and 6 a.m., each apartment must be heated to a temperature of at least 55 degrees Fahrenheit. Quite technical, but essentially between the months of October and May, heat should be consistently supplied to your apartment. You shouldn't have to supplement your heating with a heater. Those aren't safe. People try to do that. Some people turn on their stoves in really sort of situations that's really unsafe. You have rights as a tenant, and sort of allow the landlord to skate by opening your oven and turning your oven on or using a heater. It's unsafe and it's not your responsibility. Okay, hot water. So landlords must provide all tenants in multiple dwellings with both hot and cold water. Hot water must register at or above a constant temperature of 120 degrees at the tap. If a tub or shower is equipped with an anti-scaled valve that prevents the hot water temperature from exceeding 120 degrees, the minimum hot water temperature for the tub or shower is 110 degrees. Now, when it comes to water, obviously, if you've agreed to pay for water in your lease, then that's something that you have to pay for. But generally, water is included with rent. It just depends. Okay, now let's talk about the security deposit. So security deposit maximum. A landlord may only collect the first month's rent and security deposit. The security deposit can't be more than the rent amount. It can only be up to that amount. So essentially, when you move in, you'd be paying about 2 rents. That's it. Collecting the last month's rent is no longer legal in New York State. The Housing Stability and Tenant Protection Act enacted that law back in June of 2019 as well. Security deposit interest. If the rental property contains 6 or more units, a landlord is required to keep the deposit in a New York State interest-bearing bank account, and must collect interest on behalf of the tenant. I mean, yes, this is the law. I would say in my personal experience, I've never actually received any interest from my security deposit. So this is a tough fight to fight, tough battle to fight. Technically speaking, this is what they're supposed to do, but they don't generally give you back any interest. And it's probably so minimal anyways that depending if you've lived there for 20 plus years, it might be in your interest to pursue that though. Okay, separate security deposit bank account. So a landlord cannot mingle deposit funds with personal funds. Deadline for returning security. The landlord must return a tenant's security deposit within 14 days after the tenant has surrendered the rental property to the landlord. This is changed too by the Housing Stability and Tenant Protection Act. Before, it was a reasonable amount of time, which was interpreted to be around 21 to 45 days. If you don't receive your security deposit after those 14 days, your landlord must provide you with an itemized statement of exactly where all those funds went. And it's not just a blank, cleaned apartment. It would need receipts, actual, like I said, itemized statement of where every dollar went, because if they only used a portion of it, they can't keep the rest of it. They have to give you the rest of it. Okay. Receipt of deposit. So after a security deposit has been placed into a financial institution, the landlord must notify the tenant in writing, and also transfer of property ownership. Deposit must be transferred within 5 days of property transfer. So if the ownership has changed hands while you're still occupying the premises, you don't pay another security deposit. Your security deposit is transferred to the new owner. Okay, now we're going to get into a sad topic. I don't like these. Evictions. So in New York, a tenant can be evicted for not paying rent. These are called non-payment evictions. And for violating a lease or rental agreement, these are called holdover evictions. And a tenant may have a defense available to challenge an eviction for one of these reasons. Grounds for eviction. A tenant can be evicted in New York State for different reasons, the most common of which is failing to pay rent. In order to legally evict a tenant, however, a landlord must get a judgment from the court allowing the eviction to occur. This is true for each and every time that an eviction takes place. It must be through a judicial procedure. And we'll go through exactly what that means. So before the landlord can file an eviction lawsuit with the court, the landlord must give the tenant notice. Eviction for non-payment of rent. So before the landlord can evict for failing to pay rent, the landlord must give the tenant a 14-day notice to pay or quit. That was again extended from 3 days, I believe, with the Housing Stability and Tenant Protection Act. I believe it was 3 days. The notice must state that the tenant has 14 days to pay the rent or move out of the rental unit. However, the Housing Stability and Tenant Protection Act has allowed tenants to pay up that amount that's owing all the way until the hearing. So even if you've received notice of petition and petition of eviction for non-payment because you didn't pay within those 14 days, and for some reason you were able to collect the funds right before the hearing, you can hand them to your landlord that day in court, and they must accept it and withdraw their petition because you've cured the defect. When it comes to non-payment, essentially it's stating the landlord wants to continue the landlord-tenant relationship with you. They just want money from you. They don't want to terminate the tenancy. They want to continue the tenancy. They just want money. But when it comes to evictions for lease violations, that's a completely different idea. And what they're trying to do there, I don't even know if this looks right. Okay. And what they're trying to do there is terminate the landlord-tenant relationship. So they don't want to continue the landlord-tenant relationship, and they want possession of their property. So if a tenant violates the lease, the landlord must give the tenant notice to cure the violation. They usually don't, but generally what they're supposed to do is give you a letter and say, listen, you did this, or this is your first warning, you have 2 more, something like that. It depends on their policy. Your lease should explicitly state kind of what the landlord's intended plan of action is upon a lease violation, but they don't always do that. But what's usually supposed to happen is if you violate the lease for, say, smoking in your apartment or having an unauthorized guest or something like that, your landlord should issue you a notice of lease violation, and you should have like 1, 2, or 3 of those. It depends on the degree of harm. So if it's a really serious thing where there's illegal activity or you've put other tenants at risk, your landlord doesn't have to give you 3 notices. 1 notice is sufficient. and it can actually be the notice of termination. But if it's minor sort of violations, then you should be entitled to more. And if you're in subsidized housing or have a Section 8 voucher, then there's higher standards as well. It can't be a minor violation of the lease. It needs to be something more material. So if they wanted to renovate the apartment, that's not a legitimate reason to vacate a person who's on subsidized, who's living in subsidized housing, or a Section 8 tenant. That can be sufficient, though, for a private landlord-tenant relationship where the tenant is on a month-to-month basis. If the landlord wants to renovate the apartment, they can say you need to leave. It's a no-fault termination, really, in New York State for month-to-month tenancy. So they don't have to provide a reason why they're terminating your tenancy in a month-to-month tenancy. They just have to state that they are and provide the proper notice. So in evictions for lease violations, if the tenant does not fix the violation within the given period, the landlord must give the tenant a notice of termination. The notice of termination, again, will depend on the length of occupancy. The tenant has at least 30, 60, or 90 days to move out of the rental unit. And how I calculate it is this. If you receive your notice mid-month, the notice period doesn't begin to trigger until the next rent is due and payable. So if you received notice today, so September 23rd, the notice period wouldn't actually trigger until October. If you received it September 2nd, I would say that the notice period wouldn't trigger until October. So if your landlord gives you notice of termination just after the month has started, they shouldn't have did that. It's essentially giving you just a lot more time. Okay, so let's go over eviction defenses in New York. Eviction defenses in New York. A tenant may have a defense available if being evicted because the tenant failed to pay rent or violated the lease. Self-help actions. So it is illegal in New York State for a landlord to evict a tenant through any means other than obtaining a court order from the judge. A landlord cannot turn off the utilities to the rental unit or change the locks on the doors or do anything that would interfere with the tenant's access to the property or use of the property. This type of behavior is often referred to as a self-help eviction. And if a landlord attempts to evict a tenant with a self-help eviction, the tenant can sue the landlord for damages. The Housing Stability and Tenant Protection Act broadened the protections here as well. It enacted RPAPL 768, which makes this type of behavior criminal. It's a Class A misdemeanor and subject to between $1,000 and $10,000 per each violation. So if they change the locks, they threw out your clothes, they turn off the electricity, and they harassed you, those are all separate violations. Another reason why you may defend your eviction in New York State, the landlord does not follow proper eviction procedures. So when evicting a tenant is very important. This is all statute based. So if your landlord is at all off, the proceeding may be dismissed for procedural reasons, usually. So it is very important that the landlord carefully follows all the procedures set forth in New York State law. Otherwise, the eviction may not be valid. For example, if a landlord must give the tenant a 14-day notice before evicting a tenant for failing to pay rent, if the landlord does not give the tenant any notice but files the eviction lawsuit anyway, the tenant can use lack of notice as a defense of the eviction, and the eviction proceeding should be dismissed. This really is almost like a stall tactic, though, because it just delays what's going to inevitably happen if your landlord wants you evicted. They'll just issue you that notice and then proceed, but you cost them some money, you cost them some time, and it also buys you a little bit more time, too. Now, if your landlord evicts you for not paying rent and you actually did pay rent and you can prove that through receipts, that's a defense. Or if you are able to pay up before the time of the hearing, as I mentioned before, that's also a defense. So you really can I wouldn't advise to do that because it's kind of a waste of the court's time and your landlord's time. If you're able to pay as soon as possible, that's best. But if you don't have the funds and they only become available to you leading up to the hearing, you can present them then and you can maintain your tenancy that way. Now, if your landlord breaches the implied warranty of habitability that I discussed before, that is an affirmative defense that you would raise in court. Usually that's for non-payment. So if your landlord if you've decided to withhold rent, well, actually, we'll get into that in a second. Housing codes are established to ensure that residential rental units are habitable at the time of rental and during the tenancy. New York State imposes an implied warranty of habitability on all lease agreements, and this requires the landlord to substantially comply with building and housing codes standards. If the lease contains a clause waiving the implied warranty of habitability, a court will refuse to enforce that clause. Those are invalid clauses. The rest of the lease will hold up, but just that clause will be redacted or taken out. In New York, a landlord is required to maintain a unit in fit and habitable condition. This means the landlord must supply the rental unit with the necessary utilities, including running water and heat, and then make any necessary repairs as needed. If the landlord fails to make necessary repairs or supply necessary services, the tenant may have a few options. So you can withhold your rent until the landlord makes the necessary repairs. These are difficult things to gauge. You know, you aren't really entitled to withhold all of your rent. You aren't entitled to withhold all of your rent because your faucet doesn't work, or you aren't entitled to withhold all of your rent because your stove isn't working. It's really the thought process is kind of like a diminution in the value of the apartment. So what your apartment was valued at with everything working or with everything properly functioning, and then what it is valued at with these things not properly functioning or not being repaired. That's how you should think about it mentally. So obviously, it's not a clear set. There's no chart you can look at and says broken sink. Okay, you withhold $50 per month. Okay, broken stove, you withhold 200. There's nothing that says that. So it's kind of a scale here that the court will interpret this and then determine whether your calculations that you made were proper. And this is applying to the fact that, say something is happening in your apartment, you've made multiple maintenance requests, they have not repaired those maintenance requests, and so you decide, why should I pay full rent to a landlord who is not giving me the full value of my apartment? And it makes perfect sense. The problem is your landlord will disagree with you most likely, not always. And if they do, they can commence a non-payment proceeding after giving you that 14-day notice to pay or quit. So say you don't pay the full rent, you pay 50% of your $900 rent. So you pay $450. Your landlord disagrees with you. They issue you a 14-day notice to pay or quit. You stand your ground. You say, I'm not paying the $450 because my floor has a huge hole in it or something, serious. When you go to court, you would raise that defense in court. You say, listen, this is the reason why I didn't pay the rent. Bring pictures, bring text messages. I would suggest always writing to your landlord. Don't verbally communicate these maintenance requests if possible, because there's no record of it. If you can send a text or an email or even a letter, certified receipt requested, so you have confirmation that the landlord received this letter, that's important for you to do. Aside from withholding your rent, you can also choose to make the necessary repairs. So pay a plumber, pay an electrician, pay whomever to come, and then deduct that portion from your next month's rent. So include a receipt, make a copy of it, and say, listen, I asked you on September 1st about my stairways. I asked you on September 18th about my stairways that are crumbling, the entrance stairways. And so I finally had a mason come and relay the stairway at a cost of $1,200. My rent is $900, so that covers this month and a portion of next month. Again, they can opt to disagree with you and to issue you a non-payment, excuse me, my phone's ringing. They can opt to issue you a notice of non-payment and commence a non-payment proceeding, but you would raise those defenses in court. So, like I said before, generally the court will use the following methods to calculate the proper amount of damages owed to the tenant. The court will deduct damaged property's value from the property's undamaged value, and then also percent diminution. This refers to the percentage by which the tenant's use and enjoyment of the premises has been reduced by the uninhabitable conditions, and for this, a court will review the defects materially and the length of time such defects have existed. So if you've been existing with a leaking ceiling for 6 months, that's going to be considered. It's not just, if that's been ruining your mattress or your carpeting or your, rug, those will all be considered in the damages that the tenant is entitled to. Okay, so also your landlord cannot evict based on discrimination. This is obvious, but it happens all the time. The Federal Fair Housing Act makes it illegal for a landlord to discriminate against a tenant based on race, religion, gender, national origin, familial status, and disability. And the New York State Human Rights Law also makes it illegal for a landlord to discriminate against a tenant based on creed, age, sexual orientation, marital status, or military status. If a landlord tries to evict a tenant based on any of these characteristics, the tenant can use the discrimination as a defense of the eviction. Okay, so I just obviously we're going to get into COVID and kind of the impact that this has had on land. Oh, actually, I wanted to ask if there's any questions.
There are a few questions coming in. We'll start with the first one. How can a tenant break the lease when the tenant is leaving to purchase a house?
There is no actual provision or any law that says you can break your lease to purchase a house. There is a senior citizen exemption. Sorry, there's sound coming over. There's a senior citizen exemption. It is, now I'm forgetting, I believe it's RPL 223 A and B. I'm not exactly sure on that, but essentially the only time you're entitled to break your lease without penalty is if you are a senior and you're moving into living that allows you more assistance. So if you cannot no longer live independently and you need to move into assisted living, then you can terminate your lease early with 30 days notice. And again, that needs to happen before the month. So if you want to vacate by November, then you need to provide that notice by the end of September. Additionally, if you want to vacate and you're moving into the house of a family member who will be taking care of you, that's another reason why you can terminate your lease early without penalty. But your family member will need to draft and notarize a letter and send it to your landlord stating, I am taking care of this person, they need my help, and we're living here, something of that nature. Again, you would need to provide that 30 days notice. And the other final reason is if you can't afford where you're living and you need to move into subsidized housing, then a senior who has attained the age of 62, that's for all of these I just mentioned, you must attain the age of 62 to qualify for these exemptions. Then you can also terminate your lease early if you're moving from housing you can't afford into subsidized housing. But if you're buying a house, there's no exemption for you to do that. You're obligated to stay for the term of your lease. Now, that being said, you can always negotiate with your landlord and try to terminate early, and the landlord is obligated to mitigate damages. So in the past, they would say, okay, well, you've spent 6 months on your lease, you have 6 months more. We're going to sue you for the 6 months accelerated. We're going to calculate it and sue you for that. They can't do that anymore. They have to mitigate damages by finding new renters. And a reasonable amount of time is like a month. And especially if you're in subsidized housing, there's really no reason why they wouldn't be able to replace your tenancy with somebody else within a month. And generally with subsidized housing, they're not going to come after you for that anyways. But to answer the question, you can't technically break your lease without penalty to move into a house you're purchasing.
Okay, thank you. Our next question is, are there ever background checks done on landlords or certification requirements before landlords can buy property and rent it out?
I don't know. I'm assuming that there's definitely, processes and procedures to becoming a landlord. You have to make sure that the property has the proper licenses and permits for that, like occupancy and et cetera, like that. You need to make sure that it's up to code, housing code, building codes. But in terms of the landlord itself, I'm not sure.
Okay. And then we have, I think you covered evictions for lease violations of a lease is a true even with illegal activities such as growing drugs, etc. I think you touched on that earlier.
Yeah, so illegal activities are illegal, right? So of course they are considered a lease violation. Um, and right now, even during the COVID period, I think depending upon how egregious the situation is, if there was something really serious, the landlord might be able to I mean, they still can't proceed with evictions, but I would, yeah, of course, illegal activities do count as a lease violation, and they tend to be taken more seriously. So, I don't know whether it's kind of unclear to me whether the landlord, if say you've occupied the space for 6 years, so you're entitled to 90 days notice, but there's been illegal activity and your landlord can point to it. I think if they just give you 30 days notice, they can commence the proceeding and, state to the court, hey, listen, the reason why we accelerated this was because there was illegal activity.
Okay. And then let's see. Our next question you might be covering in your next section of this presentation, but let's try and find out where it was. Non-payment evictions, are they on hold with COVID?
Yes, I am going to cover that.
Okay.
Okay,
that's
so
it
let's
then for questions.
Okay, thanks, Christine. We're going to move into the COVID-19 period. So under normal circumstances, when tenants don't pay rent, landlords have the option of terminating the tenancy, as we discussed before. When tenants don't pay the rent or move out by the deadline given the notice, the landlords can file an eviction lawsuit to have tenants physically removed from the rental unit. However, health and safety concerns due to COVID-19 have led many states, cities, counties, and courts to place moratoriums on evictions. The scope of these temporary bans on evictions varies greatly. Some have banned any and all action relating to evictions, while others have simply postponed hearings on evictions until the court can arrange a hearing via telephone or video. Okay. So now it's even been, Harbor should be HOBOR. Sorry, Harbor is misspelled. But anyways, so there's been a lot happening. I think that everybody's kind of confused with all the chaos that's going on. There's nothing to do to change that. It's just stay abreast of everything and keep up to date, and that's all you can do. There isn't nobody has the answers right now. And a lot of my tenants or clients are saying, well, give me a specific answer, and I really can't. All I can do is let them know what's happening now and what we maybe kind of foresee will happen, but there's no real specific answers that I can provide except for what's already happened. So the CARES Act expired on July 25th, 2020, and has yet to be renewed. Despite the expiration, landlords are still prohibited for evicting tenants until after the landlord gives the tenant 30 days notice of intent to file for eviction. 30 days, 60 days, 90. Section 4024 of the CARES Act imposed a temporary eviction moratorium applying to certain dwellings that were assisted by the Community Development Block Grant, loans including Section 108 guaranteed loans, Neighborhood Stabilization Program loans, and CDBG disaster recovery loans. On the state level, we have the Tenant Safe Harbor Act. On May 27th, 2020, Governor Cuomo signed legislation prohibiting the courts from ever evicting residential tenants who experienced financial hardship for non-payment of rent that accrues or becomes due during the COVID-19 period. This hasn't really played out yet, but yeah, so if you have experienced financial hardship due to COVID-19 reasons and you're unable to pay your rent, your landlord cannot issue you that 14-day notice to pay or quit. The protections in the Tenant Safe Harbor Act apply to any unpaid rent accrued between March 7th and the yet to be determined date of reopening. That being said, if there are no COVID-related reasons for you not paying your rent, they can issue you the 14-day notice. It's if you've lost your job, if there's some sort of financial hardship that you suffered, Point is, though, we don't know how the court's going to interpret that. So there might be room for a person to say, I have the same income, but I've had to purchase extra foods. I've had to purchase all these extra things that have made it very difficult for me to pay my rent. I think it's going to be a difficult argument to make unless you're on Social Security, disability, or something like that. Then maybe I think you could make a colorful argument on why you weren't unable to pay your rent, even though technically your monthly income hasn't decreased at all. So this protection extends past the end of the moratorium, preventing landlords from evicting for unpaid rent during the pandemic period. So this is kind of a really novel idea because the pandemic period isn't ending, foreseeably ending anytime soon. Um, if you are suffering a financial hardship and unable to pay your rent, your landlord won't be able to evict you. We're not sure when that's going to end. Now, when it comes to notices of termination, that's a different thing. The landlord may still issue notices of termination right now, today, and the landlord even may file a notice of petition and petition of holdover proceeding, but the courts aren't giving return dates. So landlords are filing these things, but there's no return date, meaning they can't serve these papers on you. Without there being a date and time at court, they can't serve them on you. Generally, what I've been asked to do so far with um, eviction proceedings that were either commenced prior to COVID or during is they want the attorneys to get together and confer and to meet some sort of agreement. And I must admit, tenants tend to have the upper hand in these agreement proceedings because everything is so uncertain, and landlords don't really have that leveraging tool to say if you are not out by this date or else. They don't really have that tool anymore, so it's been pretty tenant friendly. That being said, I mean, I've had tenants move out during COVID and we reached amicable agreements with the landlords, and both parties were happy because sometimes the tenant doesn't want to be there anymore. You don't have to take advantage of this COVID-19 sort of leniency. You can act in a way where you're treating your landlord with respect, because I think that's important too. I don't think it's just because the COVID-19 period allows tenancies more leniency that people should be taking advantage of it if they don't really genuinely need this help. But I think that Americans were needing help before this happened, so that's probably just filling up those gaps. Okay, so on top of the Tenant Safe Harbor Act, Governor Cuomo has been issuing executive orders that include very important protections for renters. Um, as of August 20th, New York is extending a moratorium on evictions for residential and commercial tenants. At this time, eviction proceedings have been suspended, and no one can be evicted in New York State until at least October 20th. This applies to persons who are facing an eviction after receiving a notice of termination, or those persons who have already been to court and are simply waiting for a warrant to execute. Now, if you've already received a notice of termination and haven't actually received any papers, just understand that your landlord can't, I mean, it's probably going to be extended past then, but there definitely can't be any motion until after October 20th. The state is also banning late payments or fees for missed rent payments. So if your landlord is attaching late fee payments to your rent, don't pay them. You're not obligated to. Okay. So no landlord, lessor, or grantor may demand or be entitled to any payment, fee, or charge for late payment of rent occurring during the time period from March 20th to October 20th. The landlord may also use your security deposit to cover your rent. How long do you have to repay the security deposit? Landlords and tenants may enter into the agreement to use a security deposit as rent. If the amount of the deposit is less than the amount of monthly rent, this consent does not constitute a waiver for the remaining rent due and owing for that month. You still owe that additional amount. It's just covered whatever it's covered. The security deposit shall be repaid at a rate of 1/12 the amount used as rent per month. So basically you have a year to repay this. And you enter into a repayment plan where you're paying your rent plus that additional amount. And what it's doing is essentially sort of accruing that security deposit again. So you will have a security deposit that should be returned to you as stated within 14 days at the end of your lease. Okay. Okay, so I wanted to provide a few important websites. So if you want to report harassment by your landlord, you should go to the Attorney General's office. Their phone number is 212-416-8250. So the AG's website has all this information. And their email is civil.rights@ag.ny.gov. And essentially, the AG's is kind of a one-stop shop for any sort of harassment, discrimination. It's very helpful to go to her website. Tish James is great, and she has she's interested in the voices of her constituents. So, New York State Division of Human Rights complaint form is also a really important venue or outlet. So, New York State Division of Human Rights complaint form, and that's at https://dhr.ny.gov. Also, the Housing and Urban Development Department developed an eviction prevention and stability toolkit. The toolkit includes tenant brochures with tips to avoid eviction, and there's a flyer for encouraging engagement between landlords and tenants before the moratorium ends. There's also repayment agreement advice. I also wanted to touch on recently the CDC Director Dr. Robert Redfield signed a declaration determining that the evictions of tenants should be detrimental to public health control measures to slow the spread of SARS-CoV-2, the virus that causes COVID-19. So the Centers for Disease Control and Prevention, located within the Department of Health and Human Services, announced, I believe it was September 2nd, the issuance of an order under Section 361 of the Public Health Service Act to temporarily halt residential evictions to prevent the further spread of COVID-19. Now, technically speaking, we are following Governor Cuomo's orders, which extends through October 20th, but this will probably inform his next decision. Right now, the CDC order is effective September 4th through December 31st. And the reason why it is in place is because in the context of a pandemic, eviction moratoria like quarantine, isolation, and social distancing can be an effective public health measure utilized to prevent the spread of communicable disease. They're worried about when somebody is evicted, are they going to move into the household of a family member? And as that family member's household gains capacity or occupancy, the likelihood of spreading this disease is, increased by some percentage. Now, those are the lucky folks if you can move into the house of a family member. What about people who don't have anybody? They're forced to go to homeless shelters. Homeless shelters have already been made to decrease their occupancy in order to address or meet the guidelines of the CDC and other agencies. So there's less beds in homeless shelters. And so then there's the outside homeless. There's people who are forced to live outdoors when they're evicted. And in some ways, you could be better off in the sense that, you've got that social distancing, but of course, it's never better to be living outdoors. And we don't want to see that to happen to anyone. So essentially, why they're imposing, or why the CDC is stating we need to issue an eviction moratorium is because all of the reasons, all of the results, or all of the consequences of evicting a wave of people is going to increase the rate of infection in New York State. So it's really serious. And I think that right now, landlords rightfully are kind of up in arms about some of this, but at the same time, there's no real viable solution, and the priority should be human lives. So if we prioritize human lives, then obviously the tenants win. Does anyone have any questions? That's pretty much all that I've got here. And I'm surprised it went to 10:55. I didn't know it was so long.
We do have a couple of questions, Tatiana. I think they're referring specifically to codes. The first one is, if a lease says that monthly rent will increase by the amount greater than 5% at the end of the one-year term, unless the lease is renewed, which I think you spoke about, and no other notice is provided, is this considered sufficient notice of a rental increase under RPL 226-C?
It could be. It depends on how long you've been living there and how long the notice is. So if your rent is $600 and your landlord says next year it's going to be $700, which is obviously more than 5%, and you've lived there for 4 years, you can opt to consent to that, or you can opt to not consent to that, and your landlord would either, so they need to provide that notice essentially for that increase depending upon your length of occupancy. So if you've been there 4 years, it's increasing from 600 to 700, they have to give you 90 days notice of that increase. And like I said, the 90 days doesn't trigger until the next rent is due and payable. So if they were issuing that notice, say today, September 23rd, it wouldn't be effective until October, November, December, January 1st. If you've lived there for less than 4 years, it's really 2 years, 2 years or more. So if you've lived there less than 2 years, but more than 1 year, you'd get 60 days. So if that was issued today, it would be effective October, November, December 1st. And if it was, less than 30 days or less than a year, then it's 30 days. But they generally tend to be kind of consecutive with the renewal of the lease. So essentially, they're kind of one and the same. Usually the rent increase, if you decide that you don't want to agree to that increase, then it should allow you that same amount of time, the proper notice, to vacate as well. So they need to give you that proper notice, and you can either decide to continue the tenancy and pay the increase or vacate.
Okay, thank you. And then we have a couple more. Landlords have a duty to provide tenants with receipts for payments under RPL 235-E, but it does not specify any penalty. Is there a penalty that West New York courts will enforce?
Well, see, the problem with that would be more like, how would you get that case to court? Would you sue your landlord for not giving you receipts? Probably not. So that would be something where you would submit a complaint, maybe with the AG's office or with HUD or whomever is the supervising entity or whomever sort of gives them their money. You want to let them know, my landlord isn't acting appropriately, get involved. But in terms of court, I don't think there's any sort of sanction or penalty that they would issue for that. I don't think. But I think it's just more because it wouldn't actually be brought to court.
Okay. And then there's a couple with, where does the moratorium on New York evictions until October 20th come from? Is there more information somewhere someone could look at, or where that actually started?
Yeah. I would look up newyork.gov. The New York State website has all that information, and you can go into the left-hand corner and it'll have like mortgages and rent. It has all the executive orders linked there. Also, if you just Google it, there's a lot of newspaper articles or just articles generally about it. So you can look up moratorium extending evictions through October 20th, and hopefully, something will definitely come up. There's a lot more information on it, yes.
Okay, and then just one more sort of around that. Someone wanted clarification. All evictions are on hold, including lease violations as well as non-payment evictions until at least October 20th?
Yes. So right now, non-payment evictions cannot be commenced, but lease violations technically can be commenced, but nothing's being commenced right now because there's a stay. But yes, so to answer the question plainly, yes, there's no evictions happening through October 20th as of now. but your landlord can still issue that notice of termination and be prepped for court once they're allowed to commence.
Okay. So I don't see any more questions. So thank you, Tatiana. We did have a comment that this has been very informative, so that's good. And thank everyone else for joining. We are going to have a brief survey that pops up after this, if you could fill that out. And also, I hope that you'll join us again next Wednesday for our last session of the summer series. Our topic will be guardianship for incapacitated persons.
Okay,
Thank you, Tatiana.